Hey guys, welcome to my YouTube channel Rapid Law, and today in this video we'll be learning about the general differences in law of torts. So without any further ado, let's get into the video. Now let's start with the introduction of general differences. Defense in tort law excuse or justify defendant's action, and it also protects defendants from liability under specific circumstances. It is applicable in negligence, trespass, nuisance, defamation, etc. And it also aims for fair balance between plaintiffs and defendants' right. The defendant bears burden to prove the defense. Courts interpret strictly to prevent misuse. Examples of it include volunty non fit injuria, act of God, inevitable accidents. Volunty non fit injuria. It is a Latin maxim which means to a willing person no injury is done. It is when the plaintiff consents to risk voluntarily. Essential elements of it include free consent, full knowledge of risk, voluntary assumption of risk. Example of it includes spectator at a dangerous sport. In this case, Hall versus Brooklyn Auto Racing Club. In this case, it was established that spectators at a risky sport event like auto racing accepts the natural hazards involved if the organizers take reasonable safety measures. And in this case, the court held that the club is not liable for the accident, applying the doctrine volunty non-fit injuria. And if the limitation for it is consent to no more than known risks. Next is plaintiff is the wrongdoer. In this maxim, exturpi causa non oritur actio, no action arises from immoral cause. Plaintiff contributed significantly to own harm, then he cannot claim damages. Defendant not solely liable if plaintiff acted wrongfully. In this case, Pitts vs. Hunt, it was established that claimant injured during a joint illegal activity, which involved drunken driving, cannot recover damages as the claim is barred by the doctrine "Esturpi causa". It is applicable only if the proof of plaintiff's fault is proved and ensures no compensation for self-inflicted injuries under unlawful acts. Next is Act of God vis majors. It involves defense for harm caused by natural and unforeseeable events. No human intervention or negligence involved because it only involves natural and unforeseeable events like floods, storms, and earthquakes. In this case, Nicholas vs. Marshland, it was established that the defendant is not liable for damages caused by natural event, which is act of God, such as extraordinary rainfall breaching artificial pools. If the event was unforeseeable and beyond reasonable control, then it comes under act of God, and the court ruled in favor of the defendant in this case. Next is inevitable accident. It involves harm despite all reasonable care and precaution. No negligence or fault by the defendant, but still harm has happened. The case law is Stanley vs. Powell. In this case, the defendant is not liable for accidental injury during a lawful sport if there is no negligence, applying the defense of inevitable accident. And also in this case, Assam versus State Corporation Federal Limited versus Anubha Sinha. In this case, what happened is it was decided that the fire damage caused by an electrical short circuit was treated as an inevitable accident, absolving the tenant from liability. Distinction from act of God is that may include human action but without fault. In act of God, no human interaction or no human action is involved, but in this inevitable accident, actions can also be included. That is the difference between act of God and inevitable accident, and protects defendant from unavoidable accidents. Next is necessity. It is when acts done to prevent greater harm or danger. It justifies conduct otherwise unlawful. In this case, Lai vs. Gladstone, it is a 1909 case. It was held that force feeding of a hunger striking prisoner was justified in this doctrine, necessity, because to preserve a life. So the court ruled that the rights to bodily autonomy may be limited where the state actions are deemed to be necessary to prevent serious harm or death. The conditions for this is urgent necessity, good faith, or no malice. Protects public interest and safety. Statutory authority. It is when acts done in legal power or authority, not liable if within limits of authority and done honestly. The case is Wagon vs. Stuffwell Railway Company. It is a 1860 case held that railway company liable for fire damages caused to the plaintiff's property from spark emitted by their trains despite reasonable precaution. In this case, it was established that strict liability for damages caused by the non-natural use of land, creating an important precedent for nuisance and liability law. But the railway was not liable because it was acting under a legal power or authority, and the railway fire from lawful activity. It requires act to be authorized and reasonable. Only when the act is authorized or reasonable, then there is no liability. Shields public officials and corporations acting within the statute. Next is absolute and conditional authority. Absolute authority acts done under clear statute protections. Conditional authority acts done in limited or qualified circumstances. Parental and quasi-parental authority means also a defense when exercising reasonable care and supervision. In this case, Bird vs. Holbrook, it is an 1828 case held that setting a spring gun to injure trespassers without adequate warning is an unlawful activity. Even for the trespassers, the case established that the right to defend property does not justify use of harmful traps without notice. Okay, so teachers and guardians may have quasi-parental authority. These are the case laws we discussed today in this video. And if you want, you can take a screenshot of it and go through. That's all for today, guys. Thank you so much for watching this video. All the best for your exams. Subscribe to our channel.